proceed. I will return to the position of accused number 1 in due course. You may be seated. Is accused number 2 present?
Yes, she is present, my lady. I appear on behalf of accused number 2.
Yes, present. That's Ms. Ntita.
Yes.
Thank you. Mr. Fergus, you are ready to proceed.
I am ready to proceed.
Please, thank you. Accused number 3, Mr. Tinta.
I appear, my lady, and I'm accused number 3 together with my learned friend, Mr. Powell.
Thank you. And Mr. Tinta has, are you Mr. Tinta? Yes, thank you. Accused number 4, that is Ms. Simon Mandela. Are you present? And you are represented by Mr. Maseja, ma'am. Please, can you just speak up? Is that a yes? Yes. Yes, thank you. You may be seated. Accused number 5, Ms. Bomba. Yes. You are also represented by Mr. Maseja, ma'am. Yes. Yes, thank you. You may be seated. Accused number 6, Mr. Sali. You are also represented by Mr. Maseja. Yes, thank you. Accused number 7, Ms. Musango.
She is present, my lady. I confirm appearance on behalf of accused number 7.
And you are represented by?
My lady, I'm briefed by Mr. Van Heerden
Yes.
to represent accused number 7.
Yes, just give me your name again.
Mvinjelwa, my lady, from the Port Elizabeth Bar. Mvinjelwa, M-V-I-N-J-E-L-W-A.
Yes, thank you, Mr. Mujela.
Oh, please, ma'am.
Accused number 8, Ms. Wazi.
That is the court, my lady. I appear for accused number 8 and 9.
And it's Mr.
Parade, my lady.
Mufadi. For accused numbers 8 and 9.
That's correct.
Accused number 9 being a closed corporation.
That is correct, my lady.
Mufadi, am I correct that the closed corporation's name is 40 Wings,
That is correct, my lady.
not Wings?
That is correct, my lady.
Yes. Mr. Clapp, do you apply for an amendment when the closed corporation is referred to as 40 Wings?
My lady, the registration documents of accused number 9 states it as 40 Wings.
I see. 40. Accused number 10, Mr. Cumming.
I appeared for numbers 10 and 11, my lady, together with Mr. Bester. Number 11 is a closed corporation. Number 10 is the managing member of that corporation. We act for both, and they are ready to plead.
Yes, thank you, Mr. Quinn. Accused number 12, Ms. Martin. Yes. You are also represented by Mr. Masetti, Ms. Martin. Yes, thank you. Accused number 13 is the closed corporation that is represented by Ms. Marty. Is that correct? And then accused number 14 is Mr. Lugidi. And you are represented by whom?
I appear for case number 14, Advocate 14.
And are you ready to proceed, Mr.
Ready to proceed.
Okay, then let's return to the position of accused number 1.
Yes, my lady.
The propose the happens for the rest of today. Let me ask you this: would it be proper for the other accused to plead in the absence of accused number 1?
My lady, I do not think it would be proper, but especially also in light of the fact that there is some issues regarding representation for some of the accused, specifically for 5 and 6, which I was informed by Advocate Masiti that the position as explained in the virtual pre-trial meeting still persists. So in light of that additional issue, I do not believe that it would be proper for the other accused to plead in the absence of accused number 1.
Perhaps I misunderstood Mr. Maseti. Mr. Maseti, are accused numbers 4, 5, and 6 not ready to plead?
They are ready to plead, my lady, and those that are instructing me are seated there at the back. They've indicated to me that insofar as the pleas are concerned, they are willing to accommodate the accused persons, but not the trial. Then subsequent from the pleadings, we will be withdrawing our participation.
So you are going to place the pleas of accused numbers 4, 5, and 6 on record, and then you propose withdrawing?
That's correct.
Yes, thank you, Mr. Maseti.
Thank you.
Does that help you, Mr. Maseti?
My lady, I was surprised now by this address. This was
Well,
not...
it's a good surprise.
Indeed. I will not complain about a good surprise, my lady. In light of the fact that accused number 1 has his instructing attorney present and has his advocate present, and Advocate Maseti has now confirmed on record that he has indeed received instructions and consulted with accused number 1 specifically, then I was not informed of any plea explanation being forthcoming on behalf of accused number 1. I was under the impression that it would be a blanket not guilty plea. So on that basis, my lady, then I do believe we can proceed if all the accused are represented and have instructed counsel to proceed with the plea proceedings.
Is that compliant with criminal procedure act?
My lady, if we refer to the issue of prejudice, there can be no prejudice for accused number 1, but in terms of being present in court, and in the light of the fact that we specifically refer to Section 159 of the Criminal Procedure Act, subsection 2. If 2 or more accused appear jointly at criminal proceedings, and A, the court is at any time after the commencement of the proceedings satisfied, upon application made to it by any accused in person or by his representative. Roman 1, that the physical condition of that accused is such that he is unable to attend the proceedings, or that it is undesirable that he should attend the proceedings. The court, if it is of the opinion the proceedings cannot be postponed without undue prejudice, embarrassment, or inconvenience to the prosecution, or any co-accused, or any witness in attendance, or subpoenaed to attend, may, in the case of paragraph A, authorize the absence of the accused concerned from the proceedings for a period determined by the court, and on the conditions which the court may deem fit to impose. And then, double B, direct that the proceedings be proceeded with in the absence of the accused concerned. So on that basis, my lady, I will submit to this court that indeed such a order by the court for the other accused to proceed with their pleas, or for accused one's plea to be noted in his absence, does comply with the Criminal Procedure Act. The court pleases, my lady.
Mr. Maseti, you have a mandate to enter for accused number 1 in his absence.
Yes, I do. I do, my lady.
Will there be any plea explanation?
There will be no plea explanation. And further, my lady, there will be no prejudice, because if the matter is rolled over until tomorrow, when he comes, he can confirm that plea.
In terms of the section 159, subsection double B in brackets. I make an order that accused number one's plea will be noted in his absence with his consent as requested by the prosecution. Mr. Clerk, I propose that you, it's going to be rather tedious, but that you then put all the charges to all the accused, and that I then deal with the accused in chronological order.
My lady, may I address on that point?
Yes.
I have one careful consideration as to the number of charges and the number of accused, and the very real risk that some of the charges, if it is done, read out in totality, we might run a risk of each accused that was supposed to plead to each charge, we might make a mistake or skip some of the accused. So my proposal to this court, my lady, would be that I be allowed to read out the counts, let's say count 1, and the court notes the plea of the relevant accused on that count. And then we proceed in that fashion, following the counts as it's numbered, in order to prevent a situation where we make a mistake in that regard.
I don't have a problem with that. I'm sure none of the accused will have a problem with that. You may proceed then as suggested.
Thank you, my lady. My lady, then under the case numbers indicated, I will not read out the preamble of the indictment. All the parties was served with a copy of the indictment as far back as the 28th of July 2021. I will then proceed to place the charges on record in the fashion as indicated. That will take us, my lady, to page number 20 of the indictment. Count 1, count of fraud, read with the provisions of Section 51 of Act 105 of 1997. In terms of Section 156 of the Criminal Procedure Act, only accused 1 to 9 and 14 needs to plead to this charge only leveled against them. The charge reads as follows. In that, during 6 December 2013 to 19 February 2014, and at or near East London, in the district of East London, the accused, acting in the execution of the aforesaid common purpose, described in paragraph 40 of the preamble, unlawfully, falsely, and with intent to defraud, gave out and pretended to the council of the BCM, which is in the preamble described as the Buffalo City Municipality, my lady, and or to its municipal manager and accounting officer that 1. The Eastern Cape government required the BCM to make funds available for the transportation of mourners to the various venues where memorial services were to be held. And or 2. The request to council to make funds available was based on the said instruction by the Eastern Cape government, and that they, in brackets the accused, were not aware of any factual situation or development that could impact on the decision of council agreed to make funding available. And or paragraph 3. It was their true and honest intention that a three-quotation procurement process should be followed to procure the relevant transportation services in accordance with the legal imperatives that procurement must be fair, equitable, transparent, competitive, and cost-effective. And/or paragraph 4, in brackets, after the deviation was approved by the accounting officer, 3 independent quotations had indeed been sourced from separate service providers in the normal course of business. And/or paragraph 5, the quotation submitted by Victory Ticket 750CC contains a true, correct, and reasonable reflection of the extent of the transportation services and the cost, in brackets, value, thereof, which the service provider would be required to provide. And/or paragraph 6, the invoices submitted by and/or on behalf of Victory Ticket 750CC contain a true and correct reflection of the transportation services and the value thereof that the service provider was requested to deliver and which had already been delivered. And/or paragraph 7, the reconciliation in the report provided by Sequali and placed before Council on 19 February 2014 contained a true and correct reflection of the services rendered as charged for by Victory Ticket 750CC in the invoice referred to in paragraph 32 of the preamble. And/or failed to disclose in circumstances that all had the legal duty to disclose that, paragraph 8, Victory Ticket 750CC had been selected by accused number 1 to provide the transportation services even before the matter was raised before Council by accused number 2. And/or paragraph 9, accused 1 had agreed with Sequali to inflate the quotations in order to ensure that there would be money available for the purchase of t-shirts and catering and for other purposes as directed by accused number 1. And/or the accused, by means of the aforesaid false representations, induced the BCM Council to approve funding in the amount of 10 million rand for the transportation of mourners to various memorial services, and induced the BCM Accounting Officer to approve the application for deviation from official procurement processes on the basis that a three-quotation procurement process would be followed, and induced BCM officials to accept and approve payment of the interim invoice of 5,985,000 rand to their prejudice, actual or potential, and or to the prejudice of the BCM and or its council. And whereas in truth and in fact, when the accused so gave out and pretended, they well knew that. Paragraph 1. It was already decided outside the BCM official structures that Victory Ticket 750CC would be appointed to provide transportation services. And or paragraph 2. The Eastern Cape government did not require the BCM to make funds available for the transportation of mourners to the various venues where memorial services were to be held. And or paragraph 3. The request to Council to make funds available was part of the unlawful scheme to ensure that municipal funds could be diverted and utilized for the payment of t-shirts and catering, as well as for other unlawful purposes, as directed by accused 1. And or paragraph 4. It was not their true and honest intention that a three-quotation procurement process should be followed to procure the relevant transportation services, or to follow any process in accordance with the legal imperatives that procurement must be fair, equitable, transparent, competitive, and cost-effective. And or paragraph 5, in brackets, after the deviation was approved by the accounting officer, that 2 of the 3 quotations were forged and false in content, in that they were not obtained in the ordinary course of business from the service providers whose names were reflected on said quotations. And or paragraph 6, the quotation submitted by Victory Ticket 750CC did not contain a true and correct reflection of the extent of the transportation services that Victory Ticket was expected to deliver, and that the amount quoted was grossly overstated and inflated. And or paragraph 7, The invoices submitted by and or on behalf of Victory Ticket 750CC and the reconciliation report placed before Council on 19 February 2014 did not contain a true and correct reflection of the transportation services actually rendered, and that the amount of R5,985,000 by far exceeded the actual costs and or value of the actual transportation services delivered. And or paragraph 8. Victory Ticket 750CC have been selected by accused number 1 to provide the transportation services even before the matter was raised before Council by accused number 2. My lady, there is an alternative charge to count 1, which I will then also proceed to read into the record. The alternative charge to count 1 is that of theft, read with the provisions of Section 51 of Act 105 of 1997. In that during I will start again, my lady.
Thank you.
In that during December 2013, and at or near East London, in the district of East London, the accused unlawfully and with a common purpose and intent to steal, stole R5,585,000 by means of the method set out the property of BCM. My lady, I must apologize. I now see that the amounts differ from the main count. The amount in the alternative count should read 5,985,000 rand. My lady, if I may apply for that amendment to be made.
Yes, is there any objection to the amount in the alternative to count 1 to be amended to coincide with the amount in count 1 itself?
None.
Yes, that amendment is granted. The amount in the alternative will then read 5,985,000 rand.
As a law, please, is that
And as I understand it, these counts are in respect of accused numbers 1 through to 9 and accused number 14.
Yes, my lady, it's accused number 1 to 9 and 14, to which account 1 refers.
Mr. Maseti, have you explained count 1 and the alternative to count 1 to your client accused number 1?
Yes, I did.
And does he understand the charge?
Yes, he understands the chapter.
Yes. How does he plead to count 1?
He will be pleading not guilty.
And to the alternative to count 1?
Similarly, that too, he is pleading not guilty.
Yes, thank you. Yes, Ms. Nita? Ms.
I
Nita?
have prepared a written plea.
Yes, but I have to ask, your client is present, so I have to ask her what she pleads before you tell me what your instructions are. Ms. Nita? How do you plead to count 1? Well, let me first ask you, do you understand count 1?
Yes, I do.
How do you plead to count 1? And to the alternative to count 1? Yes. Yes, thank you, Mr. Fredericks.
My lady, I have prepared in regard to all the counts and alternative counts which my client is facing. I have prepared a written plea on behalf of my client, and I confirm that the plea is in accordance with my instructions.
Yes, thank you.
Thank you. If I
do you wish to read that plea into the record, Mr. Fairbanks?
Should I just deal then with count 1 at this stage?
Yes, I think so. Otherwise, it's going to become confusing. So let's just deal with count 1 and the alternative to count 1.
As the court pleases. I, the undersigned, Sukiswa Veronica Nita, do hereby plead not guilty to A, count 1 of fraud, as well as the alternative charge of theft. I will then deal with the other counts at a later stage.
Yes, thank you. Then, Mr. Tinta. Mr. Tinta, do you understand count 1 and the alternative to count 1? How do you plead to count 1? I beg your pardon? Not guilty. And to the alternative to count 1? Yes, thank you. Mr. Jeffries?
And the accused pleads not guilty to count 1 and alternative.
Yes. Is there any plea explanation? Yes, thank you. Ms. Simon Nzele? Ma'am, do you understand count 1 and the alternative to count 1? How do you plead to count 1? And how do you plead to the alternative to count 1? Yes, thank you. Mr. Maseti?
My lady, I confirm that the plea of not guilty on the main charge and on the alternative charge is in accordance with the instructions that we will not return to any explanation.
Yes, thank you. Then accused number 5, Ms. Gomba. Ma'am, do you understand count 1 and the alternative to count 1?
Yes, ma'am.
How do you plead to count 1?
Not guilty, ma'am.
And to the alternative to count 1?
Not guilty.
Yes, thank you, ma'am. Mr. Maseti?
Similarly, I do confirm that the plea of not guilty is in accordance with the instructions that we do hold. We will not return with any plea explanation. Thank you.
Yes, thank you. Accused number 6, Mr. Sali. Do you understand count 1 and the alternative to count 1?
Yes, I do, my lady.
How do you plead to count 1?
Not guilty, my lady.
And how do you plead to the alternative to count 1?
Not guilty.
Yes, thank you, sir. Mr. Maseti?
Similarly, as before, my lady, I confirm that that plea is in accordance with the instructions we hold. We will not return with any plea explanation.
Thank you. Then accused number 7, Ms. Mahlangu. Yes, ma'am, do you understand count 1 and the alternative to count 1?
Yes, ma'am.
How do you plead to count 1? And how do you plead to the alternative to count 1? Yes, thank you. Mr. Mbinjelwa.
This is my lady. The plea is in accordance with my instructions, my lady. We have prepared a plea explanation which is brief. May I propose that everything to the record after count number 4 is put to her, which is the last count she is charged with. It is all contained in one document. It will not make sense to read just one sentence out of the at this stage.
Mr. Clark, do you have any objection to those proceedings being followed?
No.
Yes, very well. We are now up to accused number 8. Ms. Vazi, is to understand count 1 and the alternative to count 1? How do you plead to count 1? And how do you plead to the alternative to count 1? Yes, thank you, ma'am. Mr. Pakade?
My lady, I confirm the plea is in accordance with my instructions. My lady will make no submissions in terms of section 115, subsection 1 of the
Yes, thank you. Ms. Vazi, I am also going to require you to plead on behalf of the close corporation which you are representing, which is accused number 9. Yes. How does the close corporation plead to count 1?
Not guilty.
And to the alternative to count 1? Yes, thank you. Mr. Pakade?
My instructions are the same, my lady. Instead of no, we make no submissions, my lady.
Yes, thank you. And then accused number 14, Mr. Ludidi. Do you understand count 1 and the alternative to count 1? How do you plead to count 1? I beg your pardon? And to the alternative to count 1? Yes, thank you. Mr. Corky? Yes, thank you. Mr. Clerk, have I dealt with all the accused required to plead to count 1 and the alternative thereto?
Indeed, my lady.
Yes. Do you wish to move on to count 2 then?
Indeed, my lady. My lady, I then read from page 24 onwards of the indictment. Count 2, a contravention of section 173 in brackets 5 in brackets E, read with sections 1, 118 in brackets A, and 174 of the MFMA, which is the Municipal Finance Management Act, as described in the preamble. My lady, this would be then, I just need to get that number for completeness sake. That would be Act number 56 of 2003. Read further with the provisions of the Adjustment of Fines Act 101 of 1991. In terms of section 156 of Act 51 of 1977, this count 2 is only put against accused number 1 to 7. My lady, I just want to pause here. Yes. Sorry, I just wanted to make sure of one aspect. I have done so now, if I may proceed. In that, during the period December 2013, in Attorney East London, in the District Office London, the accused, being councillors, officials, or persons envisaged in section 173 in brackets 5 in brackets E of the MFMA, unlawfully and deliberately or in a grossly negligent way, contravened section 118 in brackets A of the MFMA by interfering with the supply chain management system of the BCM, to wit, by the selection of Sequali and or Victory Ticket 750cc as service provider to deliver transportation services and to manipulate the procurement processes inside the BCM as described in paragraphs 24 to 40 of the preamble. The indictment includes the penalty provision, which for record purpose I will also now read into the record. In brackets, penalty provision section 174 of the MFMA states that a person is liable on conviction of an offence in terms of section 173 to imprisonment for a period not exceeding 5 years or to an appropriate fine determined in terms of applicable legislation. There is two alternatives to count 2, my lady. The first alternative reads as follows on page 25 of the indictment, which is a contravention of section 173, subsection 5E, read with sections 1, 115 and 174 of the MFMA. Further read with the provisions of the Adjustment of Fines Act 101 of 1991, which is also in terms of section 156 of the Act, Act 51 of 1977, only against accused 1 to 7. In that, during the period December 2013, and Attorney East London, in the District Office London, The accused being councillors, officials or persons envisaged in section 173, subsection 5E of the MFMA, unlawfully and deliberately or in a grossly negligent way, contravene section 115, subsection 2 of the MFMA, by impeding the accounting officer of the BCM in fulfilling his responsibility in terms of section 115, subsection 1A of the MFMA, to implement the supply chain management policy of the BCM, to wit, by the selection of Sequali and or Victory Ticket 750cc as service provider to deliver transportation services and to manipulate the procurement processes inside the BCM as described in paragraphs 24 to 40 of the preamble. On page 26 of the indictment, my lady, the second alternative to count 2 is stated as follows. Contravention of section 173, subsection 5A, read with sections 1, 62(1)A, 62(1)B, sorry, 62(1)D, I do apologize, and 65J, as well as 174 of the MFMA. Further read with the provisions of the Adjustment of Fines Act 101 of 1991. In terms of section 156 of Act 51 of 1977, this second alternative to count 2 is only put to accused 1 to 7. In that during the period December 2013 and Atol near East London in the district of East London, the accused being councillors, officials or persons envisaged in section 173, subsection 5 of the MFMA, unlawfully and deliberately or in a grossly negligent way, impeded the accounting officer of the BCM from complying with the provisions of section 62(1)A and or 62(1)D and or 65J of the MFMA, to wit, by the selection of Sequali and or Victory Ticket 750cc as service provider to deliver transportation services and to manipulate the procurement processes inside the BCM, as described in paragraphs 24 to 40 of the preamble. That is count 2 and its 2 alternatives, my lady.
Yes, I did, my lady. He will be pleading not guilty to the main count and not guilty to both several counts. Thank you. No explanation.
You understand the count 2 and the alternatives? Yes. How do you plead to count 2? No. How do you plead to the first alternative to count 2? No. And how do you plead to the second alternative? Thank you, Mr. Freeman.
My lady, I confirm that the plea is in accordance with my instructions, and my client elect to remain silent in this stage in regard to these counts.
Peter, do you understand count 2 and the 2 alternatives thereto? How do you plead to count 2? And how do you plead to the first alternative? How do you plead to the second alternative? Thank you. Mr. Jeffries?
Now let's confirm that he is not guilty.
Page number 4, Ms. Simon Mandela. Do you understand count 2 and the 2 alternatives thereto? Yes. How do you plead to count 2? No guilty. How do you plead to the first alternative? No guilty. How do you plead to the second alternative? No guilty. Thank you.
My lady, you confirm that the pleas I according to the instructions that will go, you will not be telling any explanation.
Thank you. Excuse number 5, Ms. Orla. Do you understand count 2 and the alternatives thereto?
Yes, ma'am.
How do you plead to count 2?
No.
How do you plead to the first alternative?
Not guilty, my lady.
How do you plead to the second alternative?
Not guilty.
Yes, thank you, ma'am. Mr. Masesi?
Similarly, my lady, I confirm that those pleas are in accordance with the instructions we hold, and it is our intention not to disclose at this stage the basis of the defense.
Yes, thank you. Case number 6, Mr. Sali, do you understand count 2 and the alternative statute?
Yes, I do, my lady.
How do you plead to count 2?
Not guilty, my lady.
How do you plead to the first alternative?
Not guilty, my lady.
And the second alternative?
Not guilty, my lady.
Thank you. Mr. Masesi?
Like previously stated, my lady, the pleas are in accordance with the instructions we hold, will not be defending any consequence.
Thank you. Case number 7, Mr. Tangi, do you understand count 2 and the alternative statute?
Yes, I do.
How do you plead to count 2? And the first alternative?
Not guilty.
And the second alternative? Thank you, ma'am. Mr. Mandela?
Yes, my lady, for the reasons in accordance with the instructions.
Count 2 was with respect to reasons 1 to 7.
That is correct, my lady. I will then proceed to read count 3 into the record, page 26 and 27 of the indictment, which is a contravention of Section 4, read with Sections 1 and 8 of the Prevention of Organised Crimes Act 121 of 1998. In terms of Section 156, this count 3 is only preferred against accused 1 to 9. In that during December 2013 in Atwell near East London, in the district of East London, accused 1, 8 and 9, being persons who knew or ought reasonably to have known that property, to wit the amount paid by the BCM to Sequali, we refer to in paragraph 32, in brackets, including the inflated part thereof, was or formed part of the proceeds of unlawful activities, and who, at all times relevant, acted in the execution of a common purpose with accused 2, 3, 4, 5, 6, and 7 to commit the offences of fraud, in brackets count 1, and money laundering, in brackets count 3, did unlawfully enter into an agreement or engaged in an arrangement or transaction with each other, and or Sequali and or Victory Ticket 750cc in connection with that property, to wit the payment of 899,000 Rand to accused number 9 for catering services, in brackets, which was expressly prohibited in terms of the instruction from National Treasury from municipal funds via Victory Ticket 750cc, which had the effect or was likely to have the effect of Roman 1, concealing or disguising the nature, source, location, disposition or movement of the said property, or the ownership thereof, or any interest which anyone may have in respect thereof, or Roman 2, enabling or assisting the accused to remove or diminish the said property, which they have acquired as a result of the commission of the offence of fraud. My lady, these, as I stated, this count 3 is preferred against accused 1 to 9.
Yes, we did that, my lady.
Count 3.
He will be pleading not guilty.
Is there any plea explanation?
None.
Yes, thank you.
Thank you.
Accused number 2, Ms. Nika. Ma'am, do you understand count 3? How do you plead to count 3? Yes, Mr.
I
Fairfax.
inform my lady that they please in accordance with my instructions and that my client will remain silent.
Yes, thank you. Accused number 3, Mr. Tinta. Do you understand count 3? How do you plead to count 3? Yes, thank you. Mr. Jeffries?
Confirm that the rules for instructions ready and the accused is not guilty.
Yes, thank you. Accused number 4, Ms. Simon Nzele. Do you understand count 3? How do you plead to count 3? Yes, thank you. Mr. Maseti?
Yes, my lady, I confirm that the plea of not guiltiness is in accordance with the instructions of the board. We are not having any explanation.
Thank you. Accused number 5, Ms. Gumba, do you understand count 3?
Yes, ma'am.
How do you plead to count 3?
Not guilty.
Yes, thank you. Mr. Maseti?
Similarly, I confirm that the plea is in accordance with our instructions and we do not intend to disclose the basis of defense at this stage.
Yes, thank you. Accused number 6, Mr. Sali. Do you understand count 3?
Yes, my lady.
How do you plead to count 3?
Not guilty, my lady.
Thank you. Mr. Maseti?
Similarly, I confirm that although that plea is in accordance with our instructions and we do not intend to disclose the basis of our defense at this stage.
Yes, thank you. Accused number 7, Ms. Mashango. Do you understand count 3?
Yes, my lady.
How do you plead to count 3? Yes, thank you. Mr. Mbinjelwa.
Accused is my lady. Accused in accordance with my instructions.
Yes, thank you. Accused number 8, Ms. Vazi. Do you understand count 3?
Yes, my lady.
How do you plead to count 3? Thank you. Mr. Pakade.
My lady, I confirm that they did in accordance with my instructions. My lady will offer no explanation.
Yes. Ms. Vazi, do you also similarly plead not guilty on behalf of accused number 9, which is the close corporation of which you are the sole member? Yes, thank you. Mr. Pakade?
That is still in accordance with my instructions. My lady, we make no submission under section 115 of the conduct.
Yes, thank you. Mr. Clark?
Count 4 and its 2 alternatives. As stated in page 27 of the indictment, I will read it out as follows. Count 4, Contravention of Section 4, regular sections 1 and 8 of the Prevention of Organised Crimes Act 121 of 1998, in terms of Section 156, only against accused 1 to 11. The main count reads as follows. In that during December 2013 in Atwell Mears, London, in the district of East London, accused 1, 10 and 11, being persons who knew or ought reasonably to have known the property to wit, the amount paid by the BCM to Sopwali, referred to in paragraph 32, was or formed part of the proceeds of unlawful activities. And accused number 1, who at all times relevant, acted in the execution of the common purpose with accused 2, 3, 4, 5, 6, 7, 8, and 9 to commit the offences of fraud, in brackets count 1, and money laundering, in brackets count 4, did unlawfully enter into an agreement or engage in an arrangement or transaction with each other, and or with Sopwali and or Victory Ticket 750cc in connection with that property, to with the payment of 1,380,000 rand to accused number 11 for the procurement of commemorative t-shirts, in brackets, which was expressly prohibited in terms of the instructions from the National Treasury from municipal funds via Victory Ticket 750cc, which had the effect, or was likely to have the effect, of Roman 1, concealing or disguising the nature, source, location, disposition or movement of the said property, or the ownership thereof, or any interest which anyone may have in respect thereof, or Roman 2, enabling or assisting the accused to remove or diminish the said property, which they have acquired as a result of the commission of the offence of fraud. First alternative to count 4, my lady. I'm just going to take some water. First alternative to count 4, my lady, starts on page 28 of the indictment and reads as follows. Contravention of Section 5, read with Sections 1 and 8 of the Prevention of Organised Crimes Act 121 of 1998. In terms of Section 156 of the Criminal Procedure Act 51 of 1977, this first alternative to count 4 is only against accused 10 and 11 and reads as follows. In that during December 2013 in Attorney East London, in the District of East London, accused 10 and 11, being persons who knew or ought reasonably to have known that another person or persons to wit accused 1 and or the ANC, through Sapali, had obtained the proceeds of unlawful activities, to wit the amount of 5,985,000 rand referred to in paragraph 32, did unlawfully enter into an agreement with accused 1 and or accused 3, and or Sapali, and or another unknown person who acted on behalf of 1 or more or all of them, or engaged in an arrangement or transaction with accused 1 and or accused 3 and or Sapali and or said unknown person, whereby the said proceeds of unlawful activities were used to acquire property on behalf of accused 1 and or the ANC, or to benefit them in any other way, in brackets, to pay for the t-shirts. The second alternative to count 4, my lady, reads as follows. It's a contravention of Section 6, read with Sections 1 and 8 of the Prevention of Organised Crimes Act. My lady, I must stop there and see that there is superlative words in the heading of the second alternative. The prevention of must be deleted, my lady, because it's repeated twice.
Yes, that amendment is made.
Thank you, my lady. I do apologize for that oversight. The Prevention of Organised Crimes Act 121 of 1998, in terms of Section 156 of the Criminal Procedure Act, Act 51 of 1977, only preferred against accused 10 and 11. In that during December 2013, an Attorney East London in the District of East London, accused 10 and 11 being persons who knew or ought reasonably to have known that another person or persons to wit accused 1 and or the ANC through Sapali had obtained the proceeds of unlawful activities, to wit the amount of 5,985,000 rand referred to in paragraph 32, unlawfully acquired, used or had possession of part of the amount so obtained by Sapali, to wit 1,380,000 rand. The penalty provision for count 4, the contraventions as listed in count 4, my lady, is stated there. Section 8 of Act 121 of 1998 provides for a fine of 100 million rand or imprisonment not exceeding 30 years. As it would be this one.
Yes, thank you. Mr. Maseti, have you explained count 4 to your client?
Yes, I did, my lady.
And how does your client plead to count 4?
He will be pleading not guilty.
Yes, that when I say your client, that's accused number 1.
Number 1 is
Yes, thank you. Yes, Ms. Nita, do you understand count 4? How do you plead to count 4? Yes, thank you. Accused number 3, Mr. Tinta, do you understand count 4? How do you plead to count 4? Yes, Mr. Jeffries. Yes, thank you. Accused number 4, Ms. Simon Mzere. Do you understand count 4?
Yes, ma'am.
How do you plead to count 4?
Not guilty.
Thank you. Mr. Maseti.
I took a temporary plea and we do not offer any place for me.
Yes, thank you. Accused number 5, Ms. Gomba. Do you understand count 4? How do you plead to count 4? Yes, thank you. Mr. Maseti.
I do confirm the correctness of the plea in accordance with our instruction, and we will not interfere with any case.
Yes, thank you. Accused number 6, Mr. Sali. Do you understand count 4?
Yes, I do.
And how do you plead thereto?
My guilty, my lady.
Yes, thank you. Ms. Maseti.
I do confirm that actually, after with respect to the board, we are not ready to give you explanation.
Yes, thank you. Accused number 7, Ms. Mahlangu. Do you understand count 4?
Yes, I do.
How do you plead to count 4? Yes, thank you. Mr. Mandela.
This is my completely in accordance with my instructions, my lady. As indicated previously, prepared a brief explanation from the allowed to be to the record.
Yes, please do.
It's a copy for the court may forward.
Just a moment, just for purposes of record keeping, I presume there are going to be a lot of exhibits during the trial, so I'm going to mark this exhibit plea 7. In other words, well, I'll mark it PE 7, the plea explanation of accused number 7. Does that suit everybody? Yes, thank you.
Well, it is a statement in terms of Section 115, Section 1 of 1977. It is as follows. I, the undersigned, on behalf of Attila Mahlangu, do hereby make the following statement and brief explanation. I understand the charges before the basement, as explained to me by my legal representatives. I hereby tender the following plea: count 1, I plead not guilty; count 2 and alternatives, I plead not guilty; count 3, I plead not guilty; and count 4, I plead not guilty. It is correct that at all times relevant to the indictment, I was employed at BCM as the Acting Director, Executive Support Services. However, I deny that I made common purpose with any person or entity to defraud and manipulate BCM's procurement processes in the execution of a fraudulent scheme as described in the indictment. Furthermore, I deny that I was ever part of any meeting held on the 9th of December 2013 or any other date that decided that part of the municipal funding must be utilized for the buying of t-shirts and catering. However, I did attend council meeting on the 11th of December 2013 where the council inter alia resolved that I provide a report in respect of expenditure of the funds that was allocated for the transport of mourners.
So it should be the funds that were allocated.
Yes, ma'am. That's correct.
Yes.
I first became involved on the 12th of December 2013 and I was called by the Chief Financial Officer, Mr. Pillay, who was then the acting city manager in the absence of Mr. Fali, in order to sign an application for deviation which he had prepared. At the same meeting on the 12th of December 2013, I learned about the fact that the 10 million rands budget will be injected into my department's budget and we were to be the end user. For this reason, I signed the application. At no stage was I involved in the drawing up of specifications, nor was I involved in any way in the appointment of the service provider, which we take at CC. My department did, however, draw up an operation plan, which was forwarded. My lady, if that could be amended, should be just come after forwarded. However, this plan was never used. That was simply
Just a moment. My department did, however, draw up an operational plan which was forwarded, and must the words "please insert" be deleted? Yes.
However, this plan was never used and was ignored. I've met Mr. Sokwali for the first time on the 21st of January 2014 in my office in a meeting that I had called in order for him to provide a detailed report on the disbursements of funds as mandated by Council on the 11th of December 2013. I met with Mr. Sokwali again in the company of his attorney and other individuals for the same reasons as described in the paragraph above on the 27th of January 2014. However, I deny, I insisted or even discussed the provision of a report that gave false account of the transportation services rendered. It is signed by accused number 7 and dated today morning.
Yes, thank you. Accused number 7, Ms. Mhlangu. Do you confirm the plea explanation as read by your representative into the record? Yes, thank you. Accused number 8, Ms. Vazi. How do you plead to count 4? Yes, thank you. Mr. Pakade.
Confirm the plea mandate is indeed in accordance with my instructions. My lady, we make no substitution for section number 5.
Yes, thank you. Ms. Vazi, do you plead similarly on behalf of accused number 9, which is the closed corporation whom you represent? Yes, thank you. Mr. Pakade.
Confirm, my lady, my instructions are still the same. Again, we make no further substitution.
Yes, accused number 10, Mr. Fanu. How do you understand count 4?
Yes, sir.
And how do you plead to count 4?
Not guilty.
Do you understand the first alternative to count 4? And how do you plead thereto?
Not guilty.
And do you understand the second alternative to count 4?
Yes, sir.
And how do you plead thereto?
Not guilty.
Yes, do you enter the same pleas on behalf of the closed corporation whom you represent, which is accused number 11? Yes, thank you. Mr. Quinn?
We confirm, the lady, the pleas are not guilty on behalf of both 10 and 11. We have prepared a written plea, a statement in terms of section 115 and tender admissions in terms of section 220 of the Criminal Procedure Act. We've reduced all of these to writing. I'll hand to your ladyship. I hand to my lady a copy.
Yes, thank you.
You'll notice it has been signed by the accused, accused number 10, both on his personal capacity and on behalf of the closed corporation. His signature signifies and confirms his plea of not guilty, and his signature also serves to confirm the contents of this statement, which I propose, with your permission, to read into the record.
Yes, the written statement will then be marked PE 10 and 11.
Thank you, Mary. So, could you give us the prosecution? May I proceed?
Yes, please, Mr. Quinn.
The statement is made on behalf of accused numbers 10 and 11. We will further refer to simply as the accused. Then it's recorded, lady, that the purpose of the statement is to indicate the essential basis of the accused offence, so as to eliminate unnecessary evidence by stipulating exactly what is disputed by the accused to the single charge, count 4, and obviously, my lady, its alternatives apparent from the undated indictment served on the accused in the Magistrates Court on 28 July 2021. I shan't read into the record the reproduction of the charges which are set out in the document at 2.1 and further. and then move to paragraph 3, which provides that the accused plead not guilty to the charge of a contravention of Section 4, alternatively Section 5, alternatively Section 6 of the Prevention of Organised Crime Act 121 of 1988 as stipulated in the indictment. And then at 4, the accused admit in terms of Section 220 of the Criminal Procedure Act and do not place in issue that they contracted with Victory Ticket 750cc to supply T-shirts, that they sourced and procured the T-shirts from Mkwabi Printers, Pietermaritzburg, that they paid the printers from own funds, rendered an invoice to Victory Ticket 750cc, and received payment from Victory Ticket 750cc. More particularly, and in terms of Section 220 of the CPA, the accused admit and do not place in issue, firstly, copies of the invoice of Mkwabi Printers, there should be invoices of Mkwabi Printers being invoice 947 and quotation 0025, which are annexed marked A and B. They admit also at 4.2 of the document a copy of the bank statement of Mkwabi Printers annexed marked C, which evidenced 2 payments from accused 11 of 604,000 Rand on 12 December 2013 and 84,560 the VAT component on 11 February 2014. Further to this, and in terms of Section 220, a copy of accused 11's invoice to Victory Ticket 750cc for 1,380,000 annex mark D, and lastly a copy of the bank statement of Victory Ticket 750cc evidencing payment by Victory Ticket 750cc to accused 11 for 1,380,000 Rand, which is annex marked E. At paragraph 5, the accused deny and place in issue that they knew or ought reasonably to have known that the payment or payments of Buffalo City Metropolitan Municipality to Victory Ticket 750cc of 5,985,000 Rand, or the payment to accused 11 of 1,380,000 Rand by Victory Ticket 750cc was the proceeds of any unlawful activity or the proceeds of theft or fraud. And then lastly, my lady, the accused have no knowledge of whether the allegation that the payment or payments of BCMM to Victory Ticket 750cc of 5,980,000 Rand, or the payment to accused 11 of 1,380,000 Rand by Victory Ticket 750cc were the proceeds of any unlawful activity or the proceeds of theft or fraud. They have no knowledge, my lady, of whether that is true and correct. They are unable to dispute those allegations and do not place those allegations in issue. Thank you, my lady.
Is it stated as this government on which date this judgment?
It was signed today.
Yesterday.
Oh, I beg your pardon, it was signed yesterday. What is the date?
18.
The 18th, my lady. Thank you, my lady.
Please, my lady. I will then read count 5 as per page 30 of the indictment into the record. Count 5 is a contravention of Section 4, read with Sections 1 and 8 of POCA, which is the Prevention of Organized Crimes Act, as stated earlier. In terms of Section 156 of the Criminal Procedure Act, only against accused number 1. In that during December 2013 in Attorney East London, in the District of East London, accused 1, being a person who knew or ought reasonably to have known that property to wit the amount of 350,000 rand referred to in paragraph 33.3 of the preamble was or formed part of the proceeds of unlawful activities referred to in paragraph 32 of the said preamble, did unlawfully enter into an agreement or engage in an arrangement or transaction with Sequali and or Victory Ticket 750cc in connection with that property, to wit, the payment of 350,000 rand to Lily Rose Trust without any valid business reason, which had the effect or was likely to have the effect of Roman 1, concealing or disguising the nature, source, location, disposition or movement of the said property, or the ownership thereof, or any interest which anyone may have in respect thereof, or Roman 2, enabling or assisting the accused to remove or diminish the said property which they have acquired as a result of the commission of the offence of fraud. Again, the penalty provision as per Section 8 of Act 121 of 1998 provides for a fine of 100 million rand or imprisonment not exceeding 30 years. This count 5 is only preferred against accused number 1.
Yes, we did, my lady. He will be pleading not guilty, my lady, and will not be tendering any explanation for that.
Thank you, my lady. I then turn to count 6, my lady, on page 31 of the indictment. Count 6, my lady, has an alternative count as stated on page 32 of the indictment. Count 6 is a contravention of Section 4, read with the provisions of Section 1 and 8 of the Prevention of Organized Crime Act. In terms of Section 1 Criminal Procedure Act, this count is, as well as its, the main count of count 6, my lady, is preferred against accused 1. The alternative to count 6 is preferred against accused 12 and 13. My lady, if I then return to the main count, count 6. My lady, the count reads as follows. In that, during December 2013 in Atholl near East London, in the district of East London, accused 1, being a person who knew or ought reasonably to have known that property to wit the amount of 100,000 rand referred to in paragraph 33.4 of the preamble to the indictment was or formed part of the proceeds of unlawful activities referred to in paragraph 32 of the said preamble, did unlawfully enter into an agreement or engaged in an arrangement or transaction with Sequali and or Victory Ticket 750cc in connection with that property, to wit the payment of 100,000 rand to accused 13, without any valid business reason, which had the effect, or was likely to have the effect of Roman 1, concealing or disguising the nature, source, location, disposition, or movement of the said property, or the ownership thereof, or any interest which anyone may have in respect thereof, or Roman 2, enabling or assisting the accused to remove or diminish the said property which they have acquired as a result of the commission of the offence of fraud. My lady, on page 32 of the indictment, the alternative to count 6 is stated, being a contravention of Section 6, read with the Sections 1 and 8 of the Prevention of Organised Crime Crimes Act 121 of 1998. My lady, I pause here. I see again there's a duplication of deleted, my lady. In terms of Section 156 of the Criminal Procedure Act 51 of 1977, the alternative to count against accused number 12 and 13. In that, during December 2013 in Attorney East London, in the District of East London, accused 12 and 13 being persons who knew or ought reasonably to have known that another person or persons, to wit accused number 1 and or Sequali, has obtained the proceeds of unlawful activities, to wit the amount of 5,985,000 rand referred to in paragraph 32, unlawfully acquired, used or had possession of part of the amount so obtained and paid over by Sequali, to wit 100,000 rand. Again, the penalty provision in terms of Section 8 of Act 121 of 1998 provides for a fine of 100 million or imprisonment not exceeding 30 years. As the court pleases, my lady. That's count 6.
Yes, my lady. He will be pleading not guilty, and we will not be tendering any plea explanation at this stage.
Ms. Martin, do you understand the concept? I beg your pardon. Do you understand the alternative to concept? Yes, ma'am. And how do you plead the two? Not guilty. And the closed corporation who you represent, and does the closed corporation likewise plead not guilty to the alternative to count 6? Yes, ma'am. Yes, thank you. Mr. Maseko?
Yes, my lady, I confirm that such pleas are in accordance with the instructions we hold. We will not be tendering any plea explanations at this stage.
Yes, thank you.
Pleases, my lady, I then proceed to read counts 7 to 12 into the record, which starts on page 32 of the indictment. Contravention of Section 4, read with Sections 1 and 8 of the Prevention of Organised Crime Act 121 of 1998. In terms of Section 156 of the Criminal Procedure Act, these charges are only preferred against accused 1. My lady, there's an alternative to these counts stated on page 33 of the indictment, which is also still preferred only against accused number 1. So I will then read the main charge into the record. Count 7 to 12, contravention of Section 4, read with the relevant sections, in that during December 2013 in Atoll near East London, in the District of East London, accused 1, who knew or ought reasonably to have known that property, to wit the amounts listed in paragraph 34 of the preamble to the indictment, were or formed part of the proceeds of unlawful activities referred to in paragraph 32 of the said preamble, did unlawfully enter into an agreement or engage in an arrangement or transaction with Sequali and or Victory Ticket 750cc in connection with that property, to wit the payment of the said amounts without a valid business reason, which had the effect or was likely to have the effect of Roman 1, concealing or disguising the nature, source, location, disposition or movement of the said property, or the ownership thereof, or any interest which anyone may have in respect thereof, or Roman 2, enabling or assisting the accused to remove or diminish the said property which they have acquired as a result of the commission of the offence of fraud. The alternative to counts 7 to 12 reads as follows, my lady. It's a contravention of Section 6 of the Prevention of Organised Crime Act, Crimes Act 121 of 1998, as previously stated, only preferred against accused 1. In that during December 2013 in Atwell near East London, in the district of East London, accused 1 unlawfully acquired, used or had possession of the property, which he knew or ought reasonably to have known that it formed part of the proceeds of unlawful activities referred to in paragraph 32, to wit, the amounts as listed in paragraph 34 of the preamble. Again, the penalty provision in terms of section 8 of Act 121 of 1998 provides for a fine of 100 million rand or imprisonment not exceeding 30 years.
Mr. Marcia, you have to explain counts 7 to 12 and the alternatives to these counts which you will count using 1.
Yes, my lady, we took him through, and
How do we plead to counts 7 through 12?
he intends pleading not guilty, and also not guilty also to the alternative counts.
Court cases, my lady. We are there on page 34 of the indictment. Count 13, which has an alternative count as per page 35 of the indictment. Count 13, the main count, is a contravention of Section 4, read with Sections 1 and 8 of the Prevention of Organised Crimes Act 121 of 1998. And count 13 is preferred in terms of Section 156 only against accused 1 and 6. The alternative count, my lady, to count 13 is preferred only against accused number 6. The main count of count 13 then reads as follows. In that during December 2013 in Atwell near East London, in the district of East London, accused 1 and 6, who knew or ought reasonably to have known that property, to wit the amount of 80,000 rand referred to in paragraph 35 of the preamble to the indictment, was or formed part of the proceeds of unlawful activities referred to in paragraph 32 of the said preamble, did unlawfully enter into an agreement or engaged in an arrangement or transaction with Sequali and or Victory Ticket 750cc in connection with that property, to wit the payment of 80,000 rand to accused number 6 by Sequali and or Victory Ticket 750cc, which had the effect or was likely to have the effect of Roman 1, concealing or disguising the nature, source, location, disposition or movement of the said property, or the ownership thereof, or any interest which anyone may have in respect thereof, or Roman 2, enabling or assisting the accused to remove or diminish the said property which they have acquired as a result of the commission of the offence of fraud. My lady, on page 35, the alternative to count 13 reads as follows. A contravention of Section 6 of the Prevention of Organised Crime Act 121 of 1998, as previously stated in terms of Section 156 of the Criminal Procedure Act, this alternative to count 13 is preferred only against accused number 6. In that, during December 2013 in Atwell or near East London, in the district of East London, accused number 6 acquired, used or had possession of property, to wit the amount of 80,000 rand, which he knew or ought reasonably to have known that it formed part of the proceeds of unlawful activities referred to in paragraph 32. Again, the penalty provision in terms of Section 8 of Act 121 of 1998 provides for a fine of 100 million rand or imprisonment not exceeding 30 years.
Yes, my lady, on on the main count and on the is in accordance with the instructions proposed. We will not disclose as to why we are pleading not guilty in this state.
Thank you, Mr.
As the court pleases, my lady, I will proceed to count 14, which is page 35, 36, and 37 of the indictment. My lady, count 14, has an alternative as per page 37 of the indictment. Count 14, the main count, is a contravention of Section 4, subsection A, subsection Roman 1, subsection AA. Alternatively, Section 4, subsection A, subsection Roman 2, subsection AA. Alternatively, Section 4, subsection A, subsection Roman 2, subsection CC. Alternatively, Section 4, subsection A, subsection Roman 4, read with sections 1, 2, section 4, subsection 2, section 24, section 25, and 26, 1, capital A, of the Prevention and Combating of Corrupt Activities Act, Act 12 of 2004, and further read with section 51, subsection 2 of Act 105 of 1997. In terms of section 156 of the Criminal Procedure Act, count 14, the main count, is only preferred against accused number 6. The same holds true for the alternative to count 14, my lady. In that, during December 2013 in Attorney East London, in the District of East London, accused 6, being a public officer who directly or indirectly unlawfully accepted or agreed or offered to accept a gratification in the amount of 80,000 rand, as described in paragraph 35 of the preamble to the indictment, for his own benefit or the benefit of another, in order to act personally or by influencing another person so to act, in a manner that amounted to, and here reference is made to section 4, subsection A, subsection Roman 1, subsection AA, the illegal, dishonest, unauthorized, incomplete, or biased exercise, carrying out, or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation, and or the alternative of section 4, subsection A, subsection Roman 2, subsection AA, the abuse of a position of authority, and or alternatively section 4, subsection A, subsection Roman 2, subsection CC, the violation of a legal duty or a set of rules, and or alternatively section 4, subsection A, subsection Roman 4, any unauthorized or improper inducement to do or not to do anything. The alternative to count 14, my lady, stated on page 37 of the indictment, which reads as follows: contravention of section 12, subsection 1, subsection A, read with sections 1, 2, 4, subsection 2, 24, 25, 26, 1A of the Prevention and Combating of Corrupt Activities Act 12 of 2004. As previously stated, in terms of section 156 of the Criminal Procedure Act, the alternative to count 14 is preferred against accused number 6 only. In that, during December 2013, in Attorney East London, in the District of East London, accused number 6 unlawfully accepted or agreed or offered to accept a gratification, to wit, the amount of 80,000 rand, as described in paragraph 35 of the preamble, for his own benefit in order to, bullet 1, improperly influence the procurement of a contract with a public body, to wit, the appointment of Victory Ticket 750cc as service provider and or sub-consultant to perform services for and on behalf of the Metro, as described in the aforesaid preamble, and or, second bullet, as a reward for so improperly influencing the procurement of the services of said Victory Ticket 750cc.
For the sixth, Mr. Solomon, you understand count 14,
Yes, I do, my lady.
and how you plead guilty?
Not guilty, my lady.
And do you understand the alternative to count 14?
Yes, I do, my lady.
How do you plead guilty?
Say no to it.
Yes, thank you, Mr. Maseti.
Yes, my lady, I do confirm that the pleas of not guilty are in accordance with the instructions we hold. At this stage, we will not be stating as to why what is not guilty.
Thank you. Yes, count 15.
Thank you, my lady. Count 15 is on page 37 of the indictment, and it runs over up to page 39 of the indictment. There is an alternative to count 15, my lady, which is stated on page 39. Both these counts, the main count and the alternative, is preferred only against the case number 1. Until section 156 of the Criminal Procedure Act, my lady. Count 15, the main count, my lady, reads as follows. Contravention of Section 4, subsection 1, subsection B, subsection Roman 1, subsection AA. Alternatively, Section 4, subsection 1, subsection B, subsection Roman 2, subsection AA. Alternatively, Section 4, subsection 1, subsection B, subsection Roman 2, subsection C. Alternatively, Section 4, subsection 1, subsection B, subsection Roman 4. Read the sections 1, 2, 4, subsection 2, 24, 25, 26, 1A of the Prevention and Combating of Corrupt Activities Act 12 of 2004, and further read with the provisions of Section 51, subsection 2 of Act 105 of 1997. As previously stated, referred only against accused 1. In that, during December 2013 in Athelmere, East London, in the district of East London, accused 1 being a person who unlawfully, directly or indirectly gave or agreed or offered to give a gratification in the amount of 80,000 rand, as described in paragraph 35 of the preamble to the indictment to accuse 6 for his own benefit or the benefit of another, in order for accused 6 to act in a manner that amounted to. Reference is made, my lady, to section 4, 1B, Roman 1AA, the illegal, dishonest, unauthorized, incomplete or biased exercise, carrying out or performance of any powers, duties or functions arising out of a constitutional, statutory, contractual or any other legal obligation, and or alternatively section 4, 1B, Roman 2AA, the abuse of a position of authority, and or alternatively section 4, 1B, Roman 2CC, the violation of a legal duty or a set of rules, and or alternatively section 4, 1B, Roman 4, any unauthorized or improper inducement to do or not to do anything. My lady, the alternative to count 15 reads as follows. A contravention of section 12, 1B, read with sections 1, 2, 4, subsection 2, 24, 25, and 26, 1A of the Prevention and Combating of Corrupt Activities Act 12 of 2004. As previously stated, referred against only against accused number 1. In that, during December 2013 in Athelmere, East London, in the district of East London, accused number 1 unlawfully, directly or indirectly gave or agreed or offered to give a gratification to wit the amount of 80,000 rand, as described in paragraph 35 of the preamble to accused number 6, for the benefit of accused number 6, in order to, first bullet, improperly influence the procurement of a contract with a public body, to wit the appointment of Victory Ticket 750cc as described in the aforesaid preamble, and/or second bullet, as a reward for so improperly influencing the procurement of the services of said Victory Ticket 750cc.
Mr. Masetti, have you explained count 15 to your client accused number 1?
Yes, we did that.
And how does he plead to count 15?
Not guilty, my lady.
And how does he plead to the alternative to count 15?
Not guilty still.
Yes, thank you.
And you will not be offering explanations.
Yes, thank you.
Okay, is this one lady count 16 to 25? My lady is stated on page 40 to 41 of the indictment. Count 16 to 25 is a contravention of Section 3A, Roman 1, double A. Alternatively, Section 3A, Roman 2, double A. Alternatively, Section 3A, Roman 2, double B. Alternatively, Section 3A, Roman 2, double C. Alternatively, Section 3A, Roman 4. Read with Sections 1, 2, 4, subsection 2, 24, 25, 26, 1, capital A of the Prevention and Combating of Corrupt Activities Act 12 of 2004, and read further with provision of Section 51, subsection 2 of Act 105 of 1997. My lady, count 16 to 25, the main counts, as well as the alternative, is preferred only against accused 1. It reads as follows. In that, during December 2013 in Attorney East London, in the District Office London, accused 1 directly or indirectly unlawfully accepted or agreed or offered to accept the gratification in the amounts as described in paragraphs 33 and 34 of the preamble to the indictment for his own benefit or the benefit of another, in order to act personally or by influencing another person so to act, in a manner that amounted to, my lady, reference is made to Section 3A, Roman 1, double A, the illegal, dishonest, unauthorized, incomplete or biased exercise, carrying out or performance of any duties, any powers, duties or functions arising out of constitutional, statutory, contractual or any other legal obligation, and or, alternatively, Section 3A, Roman 2, double A, the abuse of a position of authority, and or, alternatively, Section 3A, Roman 2, double B, the breach of trust, and or, alternatively, Section 3A, Roman 2, double C, the violation of a legal duty or a set of rules, and or, alternatively, Section 3A, Roman 4, any unauthorized or improper inducement to do or not to do anything. The alternative to count 16 to 25, my lady, reads as follows. It's a contravention of Section 12(1)(a), read with Sections 1, 2, 4, subsection 2, 24, 25, and 26(1)(a) of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during December 2013, at Attorney East London, in the District of East London, accused 1 unlawfully, directly or indirectly accepted, agreed or offered to accept a gratification, to wit the amounts as described in paragraphs 33 and 34, I do apologize, of the preamble, from the supply for his personal benefit, as a reward for so improperly influencing the procurement of the services of said Victory Ticket 750cc. My lady, that's counts of 16 to 25.
Yes, Mr. Clerk, just because other accused persons are mentioned in the preamble, I'd like you just to read out paragraphs 33 and 34 of the preamble for the sake of completeness.
I will do that, my lady. I then refer the court to page 18 of the indictment. Paragraph 33 of the preamble to the indictment reads as follows. On 17 December 2013, accused 1 instructed Sequali to make the following payments: 33.1, 1,380,000 rand to accused number 11, 33.2, 899,000 rand to accused number 9, 33.3, 350,000 to Lily Rose Trust, paragraph 33.4, 100,000 rand to accused number 13, and then paragraph 34 reads, accused 1 also instructed Sequali to make various cash payments to accused 1 himself. The following cash payments were made to accused 1, to wit, 34.1, 180,000 rand, 34.2, 10,000 rand, 34.3, 60,000 rand, 34.4, 60,000 rand, 34.5, 56,000 rand, and 34.6, 40,000 rand. Those are paragraphs 33 and 34 of the preamble.
Yes, thank you, Mr. Clerk. Mr. Masetti, have you explained counts 16 through to 25 to accused number 1?
Yes, we did, my lady.
And how does he plead to those counts?
He is pleading not guilty to those counts.
And have you explained the alternative to counts 16 to 25 to accused number 1?
Yes, we did, my lady.
And how does he plead?
Pleading not guilty to those.
Thank you, Mr. Masetti. Count 26.
Thank you, my lady. I just confirmed with that with Masetti on count 16 to 25, there's also no plea explanation.
I beg your pardon?
My lady, page 42 of the indictment, as well as page 43, refers to count 26 and its alternative. Count 26, my lady, reads as follows. Contravention of Section 4A, Roman 1 AA. Alternatively, Section 4A, Roman 2 AA. Alternatively, Section 4A, Roman 2 CC. Alternatively, Section 4A, Roman 4, read with Sections 1, 2, 4, subsection 2, 24, 25, 26, 1A of the Prevention and Combating of Corrupt Activities Act 12 of 2004, and read further with Section 51, subsection 2 of Act 105 of 1997. My lady, count 26, as well as its alternative, referred only against accused 14. In that, during December 2013, an attorney in East London, in the District of East London, accused 14 being a public officer who directly or indirectly unlawfully accepted or agreed or offered to accept a gratification in the amount of 30,000 rand, as described in paragraph 35 of the preamble to the indictment, for his own benefit or the benefit of another, in order for accused 14 to act in a manner that amounted to, my lady, here reference is made to Section 4A, Roman 1 AA, the illegal, dishonest, unauthorized, incomplete or biased exercise, carrying out or performance of any powers, duties or functions arising out of a constitutional, statutory, contractual or any other legal obligation, and or alternatively Section 4A, Roman 2 AA, the abuse of a position of authority, and or alternatively Section 4A, Roman 2 CC, the violation of a legal duty or a set of rules, and or alternatively Section 4A, Roman 4, any unauthorized or improper inducement to do or not to do anything. The alternative to count 26, my lady, reads as follows. The contravention of Section 12(1)(a), read with Sections 1, 2, 4, subsection 2, 24, 25, 26, 1A of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that, during December 2013 to February 2014, at or near East London in the District of East London, accused 14 unlawfully accepted or agreed or offered to accept a gratification, to wit the amount of 30,000 rand as described in paragraph 35 of the preamble for his own benefit. First bullet, in order to improperly influence the procurement of a contract with a public body, to wit the appointment of a ticket 750cc as described in the aforementioned aforesaid preamble, and or second bullet, as a reward for so improperly influencing the procurement of services of said ticket 750cc. My lady, again, as stated, count 26 and its alternative is preferred against accused 14. Does the court wish me to read paragraph 35 of the preamble into the report?
Yes, please do.
Then I will refer the court please to page 18 of the indictment. Paragraph 35 reads as follows. Upon accused one's instruction, Sequoia also paid 80,000 rand in cash to accused 6 and 30,000 rand in cash to accused 14. That is paragraph 35 of the preamble.
Thank you. Mr. Ludidi, do you understand count 26?
Yes, I do.
How do you plead to count 26? And do you understand the alternative to count 26? How do you plead to the alternative? Not guilty. Yes, thank you. Mr. Corky? I can't hear you. Yes, thank you.
Thank you, my lady. I have noticed that we are, I've noted the lunch hour, that we are almost done.
Yes.
We have one count left. So
Yes, let's just finish. Let's finish this.
Thank you, my lady. Page 44, 45, yes, 44 and 45 deals with count 27. Count 27, the main count reads as follows. Contravention of Section 4(1)(b) Roman 1AA, alternatively Section 4(1)(b) Roman 2AA, alternatively Section 4(1)(b) Roman 2CC, alternatively Section 4(1)(b) Roman 4. Read with Sections 1, 2, 4 subsection 2, 24, 25, and 26(1)(a) of the Prevention and Combating of Corrupt Activities Act 12 of 2004, and read further with Section 51, subsection 2 of Act 105 of 1997. My lady, count 27, as well as its alternative, is preferred in terms of Section 156 of the Criminal Procedure Act only against accused 1. In that, during December 2013, an attorney is London in the District of East London, accused 1, being a person who unlawfully, directly or indirectly gave or agreed or offered to give a gratification in the amount of 30,000 rand, as described in paragraph 35 of the preamble to the indictment to accused 14 for his own benefit or the benefit of another, in order for accused 14 to act in a manner that amounted to, and here reference is made to Section 4(1)(b) Roman 1AA, the illegal, dishonest, unauthorized, incomplete or biased exercise, carrying out or performance of any powers, duties or functions arising out of a constitutional, statutory, contractual or any other legal obligation, and or alternatively Section 4(1)(b) Roman 2AA, the abuse of a position of authority, and or alternatively Section 4(1)(b) Roman 2CC, the violation of a legal duty or a set of rules, and or alternatively Section 4(1)(b) Roman 4, any unauthorized or improper inducement to do or not to do anything. The alternative to count 27, my lady, reads as follows. A contravention of Section 12(1)(b) Roman 2, read with Sections 1, 2, 4, subsection 2, 24, 25, and 26(1)(a) of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that, during December 2013 to February 2014, Attorney East London in the District of East London, accused 1 unlawfully, directly or indirectly gave or agreed or offered to give a gratification, to wit the amount of 30,000 rand, as described in paragraph 35 of the preamble, to accused 14 for the benefit of accused 14. First bullet. in order to improperly influence the procurement of a contract with a public body, to wit the appointment of the True Ticket 750cc as described in the aforesaid preamble, and or second bulletin, as a reward for so improperly influencing the procurement of the services of said True Ticket 750cc. My lady, that is the last count of the indictment.
Yes, Mr. Masetti, have you explained count 27 and its alternative to accused number 1?
Yes, we did, my lady.
How does he plead to count 27
Not guilty, my lady.
and to the alternative to count 27?
Not guilty still, my lady.
Yes, thank you.
And we are not offering any plea explanation at this stage.
Yes, thank you, Mr. Masetti.
My lady, the only aspect that I do believe we haven't dealt with was the plea explanation mentioned by Mr. Fredericks on behalf of accused number 2.
Yes, that is correct. Thank you.
I've already basically read into the record, my lady, but I do have the written plea. You already want me to read it into the... I've already pleaded to all the charges.
Yes, you mentioned that you would read it into the record after count 4 had been, I think it was after count 4 had been dealt with.
No, after count 1, my lady. I will read from count 2 onwards.
Yes, please do.
I, the undersigned, the people of Veronica and Rita, hereby plead not guilty to count 2, i.e. a contravention of section 173, part E read with section 118A and 174 of the Municipal Finance Management Act, further read with the provisions of the Adjustments of Fine Act 101 of 1991, as well as the alternative charge. Count 3, I plead not guilty to the contravention of section 4 read with sections 1 and 8 of the Prevention of Organised Crime Act 121 of 1998. Count 4, I plead not guilty to the contravention of section 4 read with section 1 and 8 of the Prevention of Organised Crime Act 121 of 1998. And paragraph 2, I elect to remain silent at this stage. Dated at East London, this the 19th day of January, signed by accused number 2.
So it doesn't contain any plea explanation
No
as
plea
such.
explanation.
Yes, do you wish to hand it into the record? Yes. You could please hand it up. Yes, the written plea of accused number 2 will simply be marked P2.
I do believe we have now been concluded the plea proceedings that we're doing next.
Yes, Mr. Clerk, I'd like to make a proposal. I think well, let me address Mr. Quinn first. Mr. Quinn, do you still intend pursuing the application for a separation of trials?
Sorry, Brady, I missed that.
Do you still intend pursuing the application for a separation of trials? Yes. As was envisaged at I think the first or the second pre-trial conference, once the pleas have been finalized by agreement, the matter would then be adjourned to continue at the Bishu High Court, which is a much bigger courtroom, and I think there's better ventilation, air conditioning, etc. I propose that be dealt with now, or do you want to continue after the long adjournment with your application in this court?
I prefer to proceed after the adjournment, after the lunch and adjournment.
Yes. Very well, Mr. Clerk.
My lady, yes, this application for separation does not, I I submit is not really relevant in terms of continuation of trial for all the accused. They are, it's only accused 10 and 11 that's bringing this application. The other accused have fulfilled their roles in terms of finalizing the plea proceedings. So perhaps the court can give consideration to adjourning the other accused and their representatives to the trial dates, which has been set for the second term being 11 April to 18 June.
But they have a right to either agree with the application or to oppose
Oppose it. I presume you are going to oppose it.
Are we be opposing the separation application?
Yes, but the other accused also have a right to have their say with respect to that application.
That is so, and I can only place on record that the prosecution has not received any indication from any of the other accused that they seek to oppose the separation application. In fact, I do believe it forms part of the papers filed. I'm referring back to the confirmatory affidavit of Mr. Skumi, that he actually dealt in the papers with that specific aspect, whether any of the other accused wish to oppose the application or wish to join the application in any way. And there has been no indication that Mr. Skumi has an incorrect understanding of their position.
Yes, Mr. Clerk, I would rather err on the side of caution. The other accused must remain throughout that application.
As the court will follow. Ladies and gentlemen, at this stage, we'll perhaps take a lunch adjournment.
Yes, it's now 1:15, is it?
My lady, I can inform that the city wish to make a submission to you.
Yes, Mr. Mafeti.
My lady, in respect of accused number 1, number 4, number 5, number 6, number 12 and 13, it is not our intention to oppose the application for separation.
Yes, thank you for placing that on record.
Similarly, accused number 2 does not wish to oppose the application. If we could be excused from further proceedings in regard to the separation application.
I've just indicated what my attitude is. They will not be excused. They must remain. Yes, I'll take the long adjournment until 2 o'clock. Court adjourned.
We can on the way continue.
Ms. de Klerk, Mr. Quinn, upon reflection, I'm of the view that it would be better for everyone if the application for separation is dealt with in the Bishu High Court. I've discussed it with both of you, and I think we have made sufficient progress. The agreement was after the pleas have been recorded, the matter would be adjourned to Bishu for continuation. So that is what I propose doing. I'm advised that there is a much bigger court available there in any event.
Thank you, my lady. I have in the meantime also received the same confirmation, and the prosecution will be in agreement with that.
Yes, but just as far as position of Mr. Maseti is concerned, Mr. Maseti, you have been instructed for accused numbers 112 and 13 by Mr. Deniso, is that correct?
Yes, that's correct.
And that position will continue?
Like as of tomorrow.
Well, at the pre-trial conference, you indicated that you may be, that the legal representatives and yourself may be withdrawing for accused numbers 4, 5, and 6.
Yes, that's what prevails.
Yes, so let's just deal with accused numbers 1, 12, and 13. Will you continue representing them?
No. I do understand that there is a process which Mr. Deniso is engaged with of finding a polished SC to deal with this matter.
A polished SC.
A polished SC.
I won't ask what that means.
And I do understand that Lawrence Otis SC was in their radar, but it does appear that his schedule does not fit with the court schedule. And they are looking now beyond expanding their search.
Yes.
And I don't think that at this stage there is a confirmation of a name.
Yes, but Mr. Deniso will then remain as the attorney for accused numbers 1, 12, and 13.
Yes, definitely, Malik.
Yes, so when they appear before me tomorrow, they will be represented by an attorney.
Attended by Mr. Deniso, yes, Malik.
Yes, very well. And the position then with accused numbers 4, 5, and 6?
My instructing attorneys have indicated, all of them, all three of them, that they intend withdrawing from these proceedings on the basis of what was alluded in that virtual meeting.
Yes.
Yes. Because there is no alternative source of assistance that the accused persons could be able to secure.
And then you will likewise be withdrawing?
Certainly, yes, Maria.
Will that be today or tomorrow?
That, as of today, once please are done.
Yes. Well, then you must bring that application so that I can then deal with their positions. Are you then applying for leave to withdraw for accused numbers 4, 5, and 6?
Yes, Maria.
Together with those instructing you?
With those that are instructing me, which are Gomana Tennis for number 4, SMG Tennis for number 5, and Matthew Mulia Tennis for number 6.
Yes. You may be seated for the moment, Mr. Clark.
With regard to accused 1, 12, and 13, I do believe the matter has been settled. Perhaps Mr. Deniso can, for record purposes, confirm so. With regard to accused 4, 5, and 6, they are then without legal representation, and perhaps then they must indicate their way forward. Whether they're going to apply for legal aid, whether if there's no funds, and that being the basis of the withdrawal application by Advocate Maseti, then the accused must indicate whether they want to apply for legal aid, and if they do not wish to apply for legal aid, what the basis of that decision is, for the court to be able to exercise its powers in terms of Section 73(2)(c of the Criminal Procedure.
Accused number 4, Ms. Simon Mandela.
You have now pleaded in this matter, and you were represented by Mr. Massetti for purposes of your plea. He advises me that he and your attorney will, as of today, no longer be representing you. Now, you have been aware for some time about arranging legal representation. This trial, as far as you are concerned, and as far as what affects you, will be continuing from the 11th of April to the 17th of June. So on the 11th of April, you must be at court with legal representation, failing which you will be required to conduct your defense in person. Do you understand that?
Yes.
Yes. Thank you. You may be seated. And then it's accused number 5, Ms. Gomba. You have heard what I've said to accused number 4. Your position is similar, is it not? Yes. So you will either, on the 11th of April, be at court with somebody who's ready to proceed with your defense, or you will have to conduct your defense in person. Do you understand that? There will be no further adjournments for legal representation. Yes, thank you. You may be seated. And then it's Mr. Sali, accused number 6. Mr. Sali, the position likewise applies to you. Do you understand?
Yes, Your Honor.
Do you understand?
Yes, sir.
So you are now going to either find somebody to represent you, or you will conduct your defense in person. Yes, thank you. You may be seated. Is Mr. Deniso present? The attorney for accused numbers 1, 12 and 13.
Yes, not yet.
He's already abandoned you, Mr. Massetti. Mr. Massetti, may I ask you, there is the problem with accused number 1 not being present today, so I am going to authorize a warrant for his arrest. The problem is that he may come to this court tomorrow and not to Bishu. May I ask, before you formally withdraw, that you give me an undertaking that you will ensure that he knows where to go and what time the proceedings continue tomorrow.
My lady, I can almost guarantee your ladyship that come tomorrow, you'll find him in peace.
Yes. Yes, thank you, Mr. Massetti. You are then given leave to withdraw. That is for accused numbers 1, 12, 13, and 4, 5, and 6. Is that correct?
That's correct.
Yes, you're given leave to withdraw, and you are thanked for assisting this court with the conduct of the pleading. Yes, in this matter, I make the following order. 1, a warrant for the arrest of accused number 1 is authorized to be held over until 20 January 2022. 2, this matter is transferred to the Bishu High Court to continue at 9:30 on the 20th of January 2022, and accused numbers 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 14 are warned to be present. 3, it is recorded that accused number 1's legal representative has undertaken to inform accused number 1 of the time and the place of the continuation of this trial. That is the order I have. Court adjourned.